Supplementary list, announcement of judgment, item number 1.
In the instant case, there is no semblance of any procedure under the old Act, nor any procedure is initiated under the new Act, namely the Right to Fair Compensation and Transparency and Land Acquisition Act 2013, apart from fixation of probable compensation on a known basis. It's also pertinent to note that the initial assessment of 46 crores has later been termed by the respondents not to be on account of award of land compensation, but for the damages that the respondents incurred due to the destruction of the crops in the year 2011, when some lands were inundated and damaged, but which has not occurred since. In this backdrop of events and circumstances where nothing is clear to facilitate conclusive adjudication, this court, in absence of any due process being adopted by respondents and looking at the plight of landowners who may or may not have been affected after 2011, but however have been pursuing this litigation, deems it fit in spite of the presence of disputed facts to direct as follows. The respondents of the PhD department shall, from available records as well by fresh survey, identify and establish as to whether the lands of the petitioners remain submerged after 2011 till date. 2. If the same after survey and examination is found to be true as alleged by the petitioners, the respondents shall initiate a process for acquisition or set portions of land that have remained submerged till date. If it is found otherwise, that after only one instance in 2011, portions of the land had been submerged, which has not occurred since. After due identification of the owners and the plots that are affected in 2011, the collector shall, from the amount of ₹5 crores deposited by the PHE, apportion a set amount as compensation to landowners after due assessment and examination of respective plots. The above noted directions have been passed considering the nature of the case, especially the stand of respondents that no land of the petition is required, nor there is any proposal for acquisition. Coupled with this fact, the impact exchequer of such acquisition will have if entered into at this stage, especially taking into account the project cost is only of about 10 crores. Further, it's also not deemed practicable or reasonable to direct the writ petitioners to seek alternate remedy or to relegate them to civil courts and subject them to endless litigation. According to ordered and directed above, this petition stands closed disposal. So the best we could do.
May just point out that the damages lordship has said record. It is 6 crore something in the record.
No, 5 crores have been deposited. Because if you wait for the other 1 crore something for damages, by the time the apportion will take a long time. If it is found, this is the direction of the court, that 5 crores already lying with the collector, that will be disbursed. If it is found that after 2011, no land remains submerged. Very peculiar case. How do you try to circumvent the entire proceedings?
Other one also they have deposited with the collector.
Other 1 crore.
Yes. As per that. Just point it out. Yes.
Item number 2.
That was not brought to notice of the court. Item number 2, yes. The services of the petitioner, as noted earlier, were on probation and observed above for the confirmation of services rest with the governing body. The opinion order which was issued at the end of probation period does not impute any misconduct, and as such the same does not cast a stigma nor can be held punitive in nature, but is of termination simpliciter. Accordingly, in view of discussions and observations made above, impugn order suffers from no infirmity, writ petition stands dismissed.
Any mention?
I'd like to mention a matter for withdrawal.
Which?
For withdrawal, that
Is
milk
this
supply.
today?
No, not listed today.
This is tomorrow.
Tomorrow. Deeply.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 22. Your Lordship, I pray that this matter may come after 4 weeks, Your Lordship.
Why 4 weeks?
Actually, the conducting counsel is from Guwahati, Your Lordship, so he's
It take
having...
4 weeks to come here.
Your Lordship.
3 weeks, okay. Yes, at the request of speakers.
Yes.
Yes.
Number 14, Your Lordship. Lordship, we have taken the consent from the other side as well, Lordship. Lordship, in this case, Lordship, we are being led by Dr. Saraf in this case. Lordship,
This,
due
this,
to
this
some
matter
issues,
has consistently been adjourned. Who is
Lordship,
on the other side?
Dr. Saraf is out of station, Lordship. Your Lordship may give a short date, Lordship.
Take a long date. Just a matter of the 4 weeks at the request of the counsel of the petitioner. Yes.
May I please your
Highly
lordship?
obliged.
May I please your lordship? Item number 18 and 20 of the hearing list.
Where is it?
Your lordship, may we please to...
Item number
Yeah,
18 and
objection.
20 she is mentioning. Mr. Abraham is out of station, so Lordship.
So I have taken consent.
After
As
2
the
weeks,
connected
Lordship.
counsel for the as a learned GA for the respondents is not in out of station. It's a matter of 2 weeks.
2 weeks, Lordship. Obliged.
Yes.
Much obliged.
My please, Lordship, I beg to mention hearing number 19, my lord. Is a matter where my brother senior also appearing, my lord. We seek for 2 weeks time, Lordship, accommodation.
Yeah, to him. 2 weeks, I request HSI as well as the counsel on behalf of the
Petitioner.
petitioners. Yes.
I do.
That's it. Yes.
Please, Your Lordship. I beg to mention item number 9 and 10.
Number?
9 and 10, Your Lordship. Kindly give 2 weeks time, Your Lordship.
Why? Where's Mr. Zarika?
He's out of station, Your Lordship.
No objection, lordship.
Then should be after 3 weeks, then your lordship.
It is a pension matter. Sit up Assam.
Lordship,
9.
do you want to transfer the pension from Assam to Meghalaya, your lordship?
2 weeks, 9. And 10?
Then let it be 3 weeks, then your lordship.
What's it? What's 10 about?
Lordship, this is roadside land where they claim compensation.
Okay, 9, 2 weeks, 10, 3 weeks. Yes.
Obliged.
My lord, I beg to mention item number 11, my lord. I'm for the respondent and I'm praying for a week's time.
Why? Mr. Kipol not here?
Miss Paul, A. Paul is appearing. She's
No.
not
You
keeping
undertook last
well.
time to argue the matter. Let's see the last order.
Yes, my lord, there's an
Yes. Then
a week's time, my lord, I'm praying.
you give undertaking. The court accepts the submission of the advocate at the bar that. See, what does the last order say? Where's Mr. Chanda?
Chanda is not here today.
He's the one. See. We'll take it up.
My lord, may take it up next week, my lord.
What is the problem? What's the matter about?
Yes, regarding, my lord, this is regarding termination of a teacher in Women's College.
Termination of a teacher.
Assistant.
When was he terminated? You're for the petitioner. When was he terminated?
Was terminated back in the year. So I've not gone through the brief, Lordship.
This is a 2020 matter, so termination, that means you're happy with a termination. Yes, this is a matter after 2 weeks. At the request of MSR Data and the counsel for the petitioner, yes.
Lordship, I beg to mention item number 16 on behalf of respondents 1 and 2. Item number
On behalf
16,
of?
Your Lordship. Respondent 1 and 2, Your Lordship. Lordship may kindly fix the matter on the
Why?
8th. Your Lordship, the conducting counsel on the last date, he had some personal difficulties. He's been preoccupied, Your Lordship. He hasn't been able to prepare the matter.
Not
Lordship,
preparing,
with the
you prepare
consent-
it.
Your Lordship, he's been conducting.
How many
the
years you practice now?
matter. 11 years running, Your Lordship.
11 years then? You can even
Lordship,
be
on the
consult
next
for senior
date-
counsel
On
after
the
10
next
years.
date, if he is not able, Your Lordship, I'll conduct the hearing. Your Lordship.
Yes. Anyway, at the
Let
request
it be
of
fixed on the 8th, Your Lordship.
MSC.
That's my-
Just a matter of 2 weeks, yes.
May I please, Your Lordship, I beg to mention item number 21, Your Lordship.
My hearing list has been decimated.
I've waited for some time, Your Lordship, maybe 2 weeks.
Here for whom?
I'm for respondent number 4, Your Lordship.
What's the matter about?
It's a pension case.
Pension case?
It's a fight between them, your lordship. Let it be 2 weeks, your lordship.
No, pension case priority. You're not getting a pension?
No, Your Lordship.
You don't know whether you're getting pension or not.
I have no, Your Lordship.
No, fight between whom? Fight respondent for the pension?
Yes, your lordship.
I mean, wives.
The wife and the sister.
Second wife.
Sister or the...
A sister of the
wife.
Who's the nominee in the service book?
She's a minor niece.
The minor niece means?
The-
You are the minor niece.
I'm
And
appearing.
you are the wife.
Second wife.
Second wife.
We have no problem, Your Lordship. If the thing is settled, then we will.
In 2 weeks, you.
Oblige.
Supplementary list, item number 3.
What is this?
Lordship, this is a contempt matter, Lordship. Lordship, the petitioner, he has already retired since 31st 3.
No, the order was set pay within 4 months. 4 months.
Lordship, 4 months.
And then what happened? What has been released till date?
Only the gratuity leave salary has been released, Lordship. However, the other increment and other post-retirement benefits has not been released.
No, that's not. It's not. It's not
Reminder has
violation.
already
It's
been
like
filed. Lordship?
the issue notice then. Third, Steam author issue notice returnable in 3 weeks. Yes, steps to be taken by I said AD within 3 days. This thereafter also.
Obliged, Lordship.
4.
I thought this is item number 4.
My Lord, White, page 24, Annexure 1.
Page
24, my Lord. Annexure 1. And advisement was made, my Lord, for the post of a lady supervisor, my Lord, in the Child Development Department. And the petitioner applied for the post, and she was selected, and accordingly she
on
was...
temporary basis, on condition they qualify the appointment.
Yes, my Lord.
Yes.
So actually she was appointed as back as in the year 2009, my Lord. But even after 13 years now, more than 13 years, no district selection committee was ever called for. No interview was called. So, but still the government has said...
It's continuing. You're being paid a regular pay scale.
Yes, regular pay scale.
You're being afforded increments.
Yes, madam.
What is, you take instructions?
I'll take instruction, my Lord. But then the thing is that, my Lord, the initial appointment, which has been referred in, this is under Regulation 3 of my Lord. And Lordship will
Doesn't
find...
matter, whatever it is, working
it
for...
stipulates, these first advertisement stipulates, my Lord, certain conditions. Subsequently, my Lord, what happened? That appointment was converted into 89 days. A period of 89 days, my Lord. That is by Annexure 10, my Lord. Lordship, page 44, Lordship will find. Now, petitioner has accepted all those appointment and she is continuing on the strength of that. I do not know, my Lord, the submission has been made about the increments and all. I do not know how can it be possible. It doesn't seem to be correct in view of, my Lord, issuance of numerous appointment order on 89 days. Lordship, it starts from page 44, my Lord, Annexure 10.
54.
Page 44, 44, my Lord.
Yes.
My Lord, Lordship will find.
No, after the initial
Yes, yes.
appointment, where's the first appointment order, Mr.
My Lord,
Sadiq?
first appointment is for 1 year. Lordship will find at page 27, 29, my Lord. Page 29 is the first appointment order. This is 23 to 2010.
Lecture 4, page 29.
Okay, that's
Page
2010.
My Lord. Now, that is, my Lord, Lordship will find, that says appointment for 1 year, my Lord. It stipulates for 1 year. Lordship, my Lord, subsequently what happened, my Lord? This 1 year period was extended by Annexure 7, my Lord, for another 1 year. Page 32, my Lord.
Now, what have you done? Why was there no regular selection then for how many years?
No interview was called, my Lord. That is a problem.
My Lord,
There.
two aspects
That's one
which...
thing, yeah, that aspect
two
very
aspects,
clearly
my
you
Lord.
have to...
One thing, there was an advertisement. Now, of course, I do not have instruction. They have stated in para 18 that the petitioner has applied, my Lord. And subsequently, my Lord,
It was
the
kept in
petitioner
abeyance.
nothing.
It
So
was
that,
kept
my
in
Lord, I have to
abeyance.
take instruction on that part, my Lord.
You heard Ms. A. sitting in his counsel, assisted by so and so. Issue notice returnable in 3 weeks. Mr. B. Barchajiner, AAG, assisted by so and so present, accepts notice on behalf of all the respondents. No further notices called for. List after 3 weeks for
That's an interim
instructions.
protection may be provided because...
That is not called at this stage, my Lord. It is already, he is already protected by it.
So up to 14.
20, 26, so 40. 3 weeks time is it given? Take you have still next month. Hold on.
Why don't one advocate appear for all instead of sprinkling around here and there? Yes.
Up to 14 same, similar.
Main list, item number 1.
Yeah, PG. The writ petition has been filed that the district council in our appeal against suspension of the Sirdar did not inquire into the matter. So they have said that a show cause notice was issued and I have replied, my lord. But now I have submitted an application, to bring on record a letter, my lord. It is page 7. 6.
Any affidavit?
Yes. This is an affidavit rejoined by the appellant to the affidavit in reply.
Yes, what do you say?
So in page 7, my lord, this is a translation of the letter. That this letter was not considered by the district council, my lord. Some people actually instigated that don't take ration from the shop, from the supplier, and then the allegation was made that I am not allowing the people to take ration from this.
No, I don't understand. What is the dispute about?
Disputed allegation was brought against me that I am the Sirdar and I am not cooperating and I am not allowing the people to take ration from the dealer.
From the dealer?
From the dealer, they had to go somewhere else for getting the license.
So you were suspended?
Suspended, yes.
What happened to suspension?
Then on being, thereafter I filed an appeal before the district council and district council upheld it without any inquiry.
Upheld your suspension?
Yes.
A permanent suspension?
Yes, my lord.
Then?
So, at least my submission is that had this letter been inquired into properly, then everything would have come that it is not my fault. It is the fault of some vested interest that they are stopping the people from taking ration from this shop.
What I don't understand. I, Shri so-and-so ration dealer,
yes,
inform you that these 11 households who used to take ration from me,
yes,
they are no longer take ration from me dealer. They are going to take from Shri B. Imli. What is your name?
My name is Nolan, my lord.
So you're not involved. You're not the dealer or the complainant here. What's your
this
link?
This is the letter by the dealer that these people are not collecting ration from him. And the same persons, they submitted a complaint to the CM that I am not allowing them to take ration.
Oh, that way?
Yes. So this letter should have been taken into consideration by the district council.
But what about the veracity of the letter? Is made by whom?
My lord, complaint is at annexure 2 of the writ petition.
Yes?
Complaint is at annexure 2 of the...
Let's see the complaint.
English translation, page 23, madam.
Complaint, annexure 2.
Yes, ma'am.
Page
23.
23.
English translation. My lord, there are 3 allegations against the petitioner.
1 second. You tell us that. No, the 11 allegations, Mr. Siddiqui, is not only contained with regard to rations, with regard to the 100-day scheme, MLGRS.
It is also one of the complaint that I am not allowing them to take from this.
No, that is only one complaint.
Yes, but other 2 are also there.
Let's see the impugn order by where you have been.
Impugn order of the district council, my lord.
First of the same.
Yes. Page 46, my lord. The last paragraph of page 47.
No, of the CM. The first one is
yes,
this
CM.
appeal.
Page
CM
46.
Orders where?
Oh, 32, my lord. 32 is the same.
Yes.
Yes. Its English translation is 33. This is to inform you that the Executive Darbar Himan Noxpung, which took place on 21/2/22, suspends you as the Sardar of Mokin Village Noxpung Siddharship for a temporary period for your shortcomings as a Sardar, since you did not even provide the residential certificate.
Okay, just stop there. Now, after you've been suspended, now inquiry was gone into, then against suspension you file an appeal.
Yes.
Now, has there been a full-fledged inquiry as yet? No.
No inquiry was there.
My lord, actually, for inquiry, there's no provision. As per the Act, Section 9 of the Appointment of and Succession of Headman Act, my lord, it provides only that opportunity of hearing must be given to the petitioner.
So, he's given opportunity of hearing?
Yes, my lord.
And these charges, they were found true?
Yes, my lord. Proceedings at page annexure A of my affidavit in opposition, my lord. So the resolution was passed at annexure B, my lord. So this proceedings was never challenged in their rejoinder, my lord.
Where is that? Annexure A?
Annexure A of my
is the affidavit by E. Jarwa, acting chief. Affidavit of this acting CM.
Yes, my lord.
Yes. So the type copy is actually this one.
Type copy is page 10, my lord. So the petitioner himself personally appeared, my lord. And page 10, my lord.
Yes. You will challenge this inquiry. And your political appeal is based on what? Let's see.
My lord, para 13 of the writ petition, my lord.
Para 13.
13, page 9. Mary.
Yes.
That the petitioners had filed an appeal under Section 9(2) of the United Khasi Jaintia Autonomous Appointment and Succession of Chief and Headman Act 1959, which provides that no headman shall be removed or punished with suspension under Section 9 unless he is given an opportunity of being heard, and therefore the Executive Committee as an appellate authority is required to confine itself to find out whether a suspended headman Sardar has been provided with an opportunity of being heard prior to his suspension.
But Mr. Siddiqui, you have challenged the initial order of suspension also. If challenging the respondent, but that is a council's appellate order, then even if we interfere with this, that means that order remains.
Yes.
Oh. So what do you propose to do? The finding is that you have been, and as shown by Mr. Khasad, you allowed or given opportunity before the Darbar to explain yourself.
Yes, to show cause
and against that you have preferred an appeal against the resolution. You have not challenged inquiry proceedings, you have not challenged, and then only against respondent number 2. So even if we say that
this proceeding came to our notice only after the affidavit was filed. Before that, we will talk to.
No, you came against an order of suspension.
Yes.
Then you obtained an interim. You got an interim stay.
Yes.
And after hearing, the stay was vacated and the order was upheld. That other order was never challenged. It's not challenged before this court. So what will happen to this case? We'll give you liberty. Otherwise, we'll dismiss it.
Well, let it come next week.
Next week, there's no point. Last time, the same. I think the same matter. You said you're supposed to take instructions.
So let the liberty.
So, after hearing at some length, let us see the council plays me out to withdraw the instant petition. However, liberty to file a fresh so advised. This prayer is allowed. Matters closed and dispose of withdrawal. However, liberty is prayed. There is no point. Come, sir.
Item number 2.
Lordship, right.
May it please, Lordship.
Yes.
Your Lordship, the matter was fixed for taking instruction as to whether payment has been made to one of the supplier or not, my lord.
Part payment, yes.
Part payment. Yes, my lord. Part payment has been made, my lord, to one of the supplier, but I have
Gotham Enterprises.
Yes, your Lordship, Gotham Enterprises.
Why? How? On what basis was the part payment made?
So there was a committee which was constituted in 2019, my lord, and subcommittee recommended, and based on that, some part payment has been made. To my mind, my lord, and according to me, that payment should not have been made, my lord, because what I see, my lord, that there are contradictions in the cases of petitioners, and these in the name of flash flood, my lord, they are asking for 6 crore rupees, both item 2
No,
and
yes,
item
no, we
15,
understand
my lord.
that. We were prepared to dismiss these matters, but then let them seek other remedy, or if they don't. The thing is that Mr. Charesu last occasion said that on the basis of similar facts and circumstances, some payment was made to one of the suppliers. That is why this court wanted to know on what basis. And now you say that payment was made. You come up with proper instructions how much it was paid and whether the conditions of supply were the same. Mr. A. Kumar, Advocate General, yes.
We would like to file additional affidavit to bring on record to the bills which we have submitted to the state government. The bills which we have submitted.
Not necessarily. Yes, Mr. A. Kumar, Advocate General, submits that on instructions, or he has received instructions that a part payment was made to one of the suppliers. Stop. He prays without to bring the details on the next date. According to this matter, after 1 week.
Your Lordship, because I will be required to consult all the
2 weeks.
After 2 weeks, Your Lordship. After 2 weeks, Your Lordship.
You saved the day, Mr. Chandra. Otherwise, they were on the brink of being.
Yes, Your Lordship. Item 2 and 15 both are identical matters. 2 and 15.
3.
May I please, Your Lordship?
1 second, let the file come. Yes.
We would like to withdraw with liberty to file if there are some development, Your Lordship.
Okay, MS S. Marpana submit that due to some developments may be permitted to withdraw this petition or liberty to file afresh, so advised. Stop. Prayers allowed, matters closed on withdrawal, with deputy as prayed.
4.
Lordship, this is a contempt matter where no contempt has been made out against respondents.
May I pray to have it in second call?
No, because see,
they are talking about
to seek instructions.
Yes, my lord. In fact, we had the client had appeared yesterday and had a word with Mr. Paul. I guess
the client appeared where?
He had come to our office. In fact, instruction has already been received.
You could not speak to him.
I did not speak, my lord. Mr. Paul had spoken to him, so he's in his legs in the DB, my lord. They have it in second call, my lord. All right.
5.
Your Lordship, in this matter, on the last occasion, we had taken fresh steps again.
Yes, they are appearing, I think.
Yes, my lord. We are
when will you file affidavit?
We'll file an affidavit.
You have 4 respondents number?
1 and 2.
1 and 2.
1 and 2, my lord.
Mr. S. Thapa, Learned Counsel, has entered appearance without respondent 1 and 2. As such, service is complete. He prays for and allowed 2 weeks' time to file affidavit. This thereafter and so on.
6.
May I please, Lordship? Your Lordship, in this case, I have filed one miscase, Your Lordship, to bring.
1 second.
To bring the record development during the pendency of this verification, Your Lordship. Yeah,
what happened? Where's the affidavit?
Lordship,
they have not filed.
We have sent the affidavit for wetting, Lordship.
When do you send it out? Next, I'll ask for the correspondence. When do you send it? When do you send it, and when are you going to receive it?
Lordship, I pray for 1 week, Your Lordship. Kindly now.
This was last order was 12th. 2 weeks means plus 14. Yes, what are you saying, Mr. Nyota?
Your Lordship, prisoner here being aggrieved by non-regularization and non-release of her salary, Your Lordship, been approached before this honorable court, Your Lordship. But during the pendency of this petition, Your Lordship, the respondent number 3 issued one notice, Your Lordship, to the respondent, which terminate me from the service, Your Lordship.
Did you see that?
Your Lordship, in my miscase, Your Lordship, page.
Where's the miscase? We find
page
miscase.
number 8, Your Lordship. The respondent number 3, despite his knowing very much, Your Lordship, that this case is pending here, Your Lordship, but still.
Yes, why do you terminate after they file the case? Why do you pass termination order? On what basis? When were you appointed initially?
I was appointed in 2009, Your Lordship.
2009, Lordship.
Why? How can you just terminate like that? Because he came to court. What is the letter which you annex at page 9?
This is the letter from the directory to the respondent.
That is what, 23rd March. This should have come by way of instructions. And why did they see with reference? This is since there's no more vacant post, who has joined should be terminated, and so accordingly it was terminated. Then why she kept officially appointed since 2009? She was extended from time to time.
Yes.
Yes, sir. Take down. The state respondents today have expressed difficulty in finding an affidavit, though 2 weeks' time have been granted on 12/4/2023. Stop. This is a miscase. Mr. D. Nyota, appearing for the petitioner, submits that while during the pendency of the case itself, the petitioner services have been terminated by order dated 25th April. You are aware of this development?
No, Lordship.
You received the public miscase, correct?
Lordship, we just received it yesterday, Lordship.
Then you didn't take instructions.
Lordship.
You have kindly be given time to seek instruction this matter.
Your Lordship, in the meantime, this.
1 second. Yes. While during the pendency of the case itself, the services of the petitioner have been terminated by an order dated 25th April 2023, issued by the respondent number, his division
number 3,
for officers, respondent number?
Number 3 issue.
Number 3. Stop. Next paragraph. MS.S. Lalu, on behalf of the Lalu GA, prays that she without to obtain instructions as she is unaware of what the developments. Stop. She's permitted 1 week's time to seek instructions in this regard. The next order in the miss case, that's the main case. The main case, 1 week's time to instructions, just after 1 week. Now in the miss case, so 55 or 2023, dismissal application has been filed bring on record the factum of termination of services of the writ petitioner, who stated to have been working in an officiating arrangement since the year 2009. Stop. The said termination has occurred when termination also been passed after the writ petitioner approaches court seeking regularization of her services. Stop. Next, in this view of the matter, the termination order dated 25/4/2023 shall not be given effect to during the pendency writ petition. Yes. Yes, after 1 week, file affidavit. You don't file, we take the records, we can pass orders, just give the instructions, you don't need the...
7.
Yes.
The respondents are yet to file their affidavit.
We have given further 6 weeks time, my lord.
Any urgency?
Your Lordship,
This promotion and reversion, my lord. There is no urgency.
Mr. B. Silent, AG prays for and allowed further 2 weeks time to file affidavit. Just thereafter.
2 weeks, Your Lordship.
2 weeks, yes.
But 3 weeks, my lord.
2 weeks, Ms. Moon.
Ali Obaj.
Hearing, item E.
1 second, Ms. Amzalma. Yes.
Lordship, this item may be passed over for today, Lordship.
Why?
Lordship, in this matter, we have prepared a written argument, Lordship. We have sent it to the petitioner, Lordship.
When did we ask for an argument? We have not asked for an argument. With the permission of the court, how can you file written arguments? Was it heard? Then?
It was
Who are you? What's your name?
R. Deka, Lordship, on behalf of R. Majumdar.
Mr. R. Deka, on behalf of Argos, please that the matter be adjourned as counsel is not available. List after 2 weeks. Yes.
12.
Your Lordship, I pray if this matter may be taken up at the end of the board, as learned DSGI is still on legs.
What does the affidavit say, Mr. Yovin?
My lord, actually they have filed 2 affidavits now. Which affidavit they are relying, my lord?
It'll be the subsequent one, the last one.
The last one. In the last affidavit, what they are saying is, my lord, since my termination, they have terminated my the appointment, and I was provisionally then after, it makes no sense my joining or the HOD allowing me to join or not. So therefore, I cannot claim regularization. I cannot claim that I was working that period, and I am not entitled to the to any remunerations also. So this is the stand that they are taking. But the question that I was asking, my lord, and in that grievance before my lord is that whether the termination was just, whether the termination was tenable in the eye of law, because on what basis they have terminated me? On the basis of an adverse remark. And this adverse remark has come from where? It has come from nowhere. My 3 years.
It came from nowhere, then how was it taken into consideration?
Exactly, that is where.
It came from nowhere.
My lord. There's no substance.
Who's the author of that adverse remark entry?
It is the dean, my lord. Dean.
Is he the reporting authority?
He is not, my lord.
He's not the reviewing authority also.
He is not.
He is not the acceptance authority also.
He is neither, my lord. He is neither. Because now.
Then how can that adverse entry be allowed?
There is no adverse entry at all, my lord.
So for your post as assistant professor, correct?
Assistant professor, my lord.
Who's the reporting officer?
My lord, that the reporting officer, my lord, will be by HOD. Because I am working under the head of the department, my lord.
So HOD. Then who's the reviewing authority?
Reviewing authority would be, my lord. I'll have to see the service.
Will it be the dean? No.
Dean will not be the.
So the dean is the one who entered that adverse entry into your records.
He is, my lord. No, there's
into your ACR records, huh?
No. In the ACR record is excellent, my lord. We don't know.
Then how was his adverse entry taken into consideration?
I'll just show, my lord. There is no basis. That is my grievance, my lord. There's no basis. What he says is this: integrity certificate, my lord, and this is to certify that Dr. Tony Ite was a bona fide DM cardiology student with effect from 08/08/2015 to 07/08/2018 at Nigrims during the session of 2015 to 18, and senior resident doctor and ad hoc for a period of 100 days, so and so. During this period, he resorted to indiscipline, disturb academic
that's
atmosphere.
a certificate. That's not an adverse remark. That's an adverse entry in the service in the
No,
ACR.
it is not.
It's just an integrity certificate given by someone else.
Yes.
Well, we'll hear Dr. Musk.
My lord.
After some time.
My lord.
13. 13.
They have sent some instructions. However, my lord, as far as to whether statement was properly recorded or not, my lord, they could not. So far, they could not verify that fact, my lord.
Could not?
They could not verify that fact, my lord. Because in the report it says that, my lord, what had happened last time, my lord, on the last occasion when the matter was heard.
No, you see, why we ask for the records is that it appears that some inquiry was done by the block motion coordinator.
My lord.
Okay. So then that's why we said produce the records of the inquiry to see whether she's been heard or not. That's all.
So what they have
And now only reason given last time was that records could not produce because there's been a change of incumbent in the office of the block mission coordinator.
That is
now where's the records?
My lord, what they have sent, my lord, it may not be sufficient, my lord, but...
Ask them to appear personally next date. You don't understand orders of the court.
No, my lord, I understand, my lord.
If we say they say your statement that an inquiry has been conducted,
my lord,
and that the writ petition was heard.
Yes.
We just want to see the inquiry.
Well, that is what I had.
Has not come from petitioner or come from you. So if they can't produce that, let them appear next day. Take down.
My lord, in that case, my lord, of course they have given, but my lord,
what have they given?
I have gone through, my lord.
That means she was never heard.
It was not sufficient, my lord. This is. So, my lord, if my lord gives me another chance, my lord.
So we don't understand orders. If they don't understand orders of the court, then we'll have to at least, not to reprimand them, but to make them understand. Let them come here.
So this, when I went through this, my lord, this is more or less.
Where is that?
These are all the same annexure.
Same annexure.
Same annexure, whatever he has parried in the affidavit in opposition. Nothing was no different was there.
Yes, by order dated 28/3/2023, this court had directed the learned government advocate to produce the records and inquiry stated to have been conducted by the block or district mission coordinator SSA, West Garo Hills. Stop. Next paragraph. On 13/4/2023, when the matter was listed, the learned GA submitted that they did not produce records as there was a change of incumbent in the said office. And as such, 2 weeks' time was granted by this court to produce the said records. Next paragraph. Today, Mr. K.B. Haji submits that he has received some instructions, but which not seem to appear to be the records as called for by this court. Stop. This court notes with disapproval the conduct of the said block mission coordinator. But however, in the interest of justice, another opportunity is granted to produce relevant records in the next state, feeling which thus concerned officer shall appear personally before this court. We'll give you 2 weeks time. You, see, you don't understand orders of court. We don't want to call anybody here.
I can understand.
This is a matter of 2 weeks.
Oblige.
17.
My Lord, in this matter, I am appearing for the managing committee. I am unable to prepare the case today, in fact, my Lord. I beg for taking up the matter next week if Lordship permits.
He's a very rare visitor, you know, to take advantage of his presence.
I had the honest impression that my senior is not available, so I was unable
to. It's very rare. So one of these rare occasions, you should take advantage. If you don't take advantage now, you won't see him again in another 3 months.
Yeah.
What to do?
Since it's not ready.
Mr. H.H. Areso appearing for respondents number 4, Managing Committee. Somebody due to personal difficulty. Pays that due to personal difficulty, the matter be adjourned for
a week, madam.
For 1 week, yes. Mr. T.T. Knowledge is counsel for the petition, no objection. This is the matter on so and so.
Second call, item number 4.
By now you obtained instruction with senior.
He's still on his legs. I have just received instruction from him. The contempt may be dropped, because it seems to have been filed on a completely.
But then you have to pay cost.
Yes,
Here,
we have to render a finding, Mr. Thapa. If on a wrong premise, you've subjected them to court proceeding, that to contempt.
Well, here what happened is.
Just see how much cost you're willing to pay.
Only this gentleman is already reeling under financial issues.
Let him do community service then. We'll introduce this new thing. You know, like they have in other countries, you do community service, you go to old age home, you know, you sit with these old people for.
Maybe a lot of.
By going old age home and helping these old people, you know, entertaining them, tell them stories.
He's already very old, my lord. He's already 70 almost.
Almost 70. It's not very old, Your Lordship, by today's standards.
Of course, he's.
Life begins at 65 now.
He's again suffering from other issues, of health issues.
What to do?
But that doesn't give him the liberty to file contempt cases without any basis, Your Lordship.
This show cause notice, my lord. He even forgot about this proceeding, my lord. This proceeding came after he approached this honorable court.
It's okay. Then we'll just drop it. It doesn't matter. Yes, Mr. S. Thapa submits that the contempt application had been filed on the misunderstanding of the facts and circumstances of the misunderstanding as to the proceedings under which the said show cause notice had been issued. So he tenders unconditional apology for the mistake that's occurred. Stop. MST Yang appearing for the respondent number 1 and so number 2, except I have no objection. Oh no, that are present on behalf so and also what to say? It's not for you to accept that it's present so and so. This court accept the apology tendered by the petitioner and the contempt stands closed.
12.
There's the last matter.
Well, I'll just point out to one page 41, my lord. Can you see the page 41? Page 41.
You finish this matter today. Can't
my lord
exhaust my list in 45 minutes. Too many adjournments in hearing. When we were juniors in Guwahati, you know, we never adjourn a hearing because we don't know when next it'll come again. That's the thing. So we sit a file and wait and rush to do it or told us he need to do it because once it's dropped on the hearing list, then like maybe for 1 year you won't see the light of day. You are very fortunate of your pendency is low, so that it keeps on recycling. Otherwise, yes.
On page 41, I wanted to show this. This is an experience certificate given to me by the dean, my lord. Dean, and this certificate is dated 10th of August 2015.
41.
My lord has gone to page 41. So it says now the second last line, it says during the above period his conduct is found to be good.
Yes.
His conduct is found to be good. Now my lord, can you look at the impugned integrity certificate that is passed on page number 57, my lord. Page number 57. Now, this is the certificate, my lord. He says that my integrity was doubtful. And my lord, he is, earlier my lord has asked me a question that who is the reviewing authority. He himself is the reviewing authority. I was just checking the
57?
The dean, 57, my lord, page 57. So, 57 is the dean. The dean, after I was selected, after I was given the appointment order, then because he did not give my integrity certificate, character certificate that was required, so now he gives me a certificate saying that my integrity was doubtful. What was his basis of saying? Absolutely not, I'm not aware. If at all I was resorted into indiscipline, I was a student, I could have been given rustication, or I could have given a show cause notice, I could have given a warning. This never had happened during the entire career of my DM, or for that matter, I was working as a senior resident doctor.
Now he's a reviewing authority.
He is the reviewing authority. Why I say so is because
from where do you get that?
Kindly look at my certificates, my lord. My reports, confidential. Page 38. Kindly look at page 38, my lord. Page 38. So these are my confidential annual assessment certificate for senior resident doctor, and this is reported by the head of the department, and this is forwarded to whom? Forwarded to DN Negrims for necessary action. I was just checking the bylaws of the Negrims, my lord.
Okay, 1 second. Right, 1 second. Now, so this is blah blah blah. This is by the reporting authority.
Yes, my lord.
So he's HOD.
Yes.
Animesh Mishra.
Yes, my lord.
Okay. Then next.
Yes, my lord. So this is one particular period. Punctuality is outstanding.
Okay, fine. Everything is outstanding.
Yes. So the
next,
next,
excellent.
Yes, my lord. Next is page 39, my lord. Page 39 also is the same.
Yeah, this is for which period?
My lord, this is the period from 08/08/2016 to 07/08/2017.
1 year, yes.
Yes. And the next one is, my lord, again, page 40. This is for the period of September 2017 to 2018, my lord.
Yes.
So these are the annual assessment certificates, my lord. If I was supposed to be given an adverse certificate,
no, I don't understand. So your ACR records,
yes,
that is only one report by the reporting authority, correct?
Yes, my lord.
Then you come to the certificate given by your reporting authority, which is given to the Dean Academics, correct?
Yes, my lord.
Now the Dean Academics issued the experience certificate at page 41.
Yes, my lord.
Experience certificate.
Yes.
And it does not show that your complete ACR. Where is it? There's no complete ACR that that ACR how it functions.
My lord.
Like you have a
documents, my lord.
And so like the assessment is done by the reporting officer.
Yes, my
who
lord.
directly contact with you. He
Yes,
does
my
the reporting.
Yes, my lord.
That Mr. Yobin
Yes.
is outstanding, fine.
Yes.
And then that's put up before the and your reasons are given,
Reviewing authority.
is put up before the reviewing authority.
Yes.
The reviews of whether your assessment is correct or not.
Correct or not.
Maybe you can go from the records and change it
Yes,
from outstanding to good or something, or to very
Yes,
good.
madam.
Correct?
Yes.
Then from reviewing also goes to the accepting authority. You
Accepting
accept the thing,
authority.
and that goes into your service records for consideration of your
Consideration
promotion,
of promotion.
whatever.
My lord.
Now here we see first thing only the reporting authority. Where's the other reports in this format? Annual assessment, for senior citizen. Where's the one?
My lord,
That does not exist.
My lord,
that means
here-
the officers here. What
My
is
lord-
what come here? What is the method for assessment?
For assessment, for each year, HOD send this ACR to the report.
That's all. That's it.
Yeah.
There's no other format for filling like the format given by the HOD.
No. One format is distributed each year.
No. Listen, this format is given by the this format at page 38. Okay. This is the annual assessment certificate for senior resident doctor. Now, for the subsequent authorities, there's no format. It's just a certificate.
No, this is I think this is the first page of this. Only it is not complete document.
Where the complete records are there?
It contains at least 6-7 pages.
Exactly.
Yeah.
That's what this court's asking.
Because here it is the marking is not here.
That's what. Where's the marking? You don't have it with you.
I don't have, my lord. Let the
No, it is.
Have the records are there with you?
No, it is actually a personal document to it. At present, I don't have it. It is given only to the concerned that employee only.
But then you sit down. You sit down.
Our section.
You sit down. Yes. Where's Dr. Mozika?
Your Lordship, he's still on legs.
We'll come back at 12 o'clock.
At 12, my lord. At 12.
You just get instructions also what this thing is human. If that's correct, that is what this court's asking. That if an ECR document or is one complete document by itself. You understand that that now the one page is there by the reviewing authority outstanding.
Yes.
Now where's the second one by the
reviewing authority.
reviewing and by the
accepting authority,
yes.
my lord. Yes.
If what he says is correct, that is a 6-7 page document.
My lord.
Yes.
I'll take instruction on that.
It's at 12.
At 12.
Yes. Yes, you got instructions.
My lord, it appears that he's in OT, my lord. Operation theatre, my lord. He's not.
See, you explain to the senior counsel where the matter is.
My lord. There isn't ACR.
But it appears, my lord, that the only issue that left now is the salary for the period March till October, my lord.
My lord, I was challenging whether after my appointment order,
yes,
giving the adverse integrity certificate, my lord, and revoking without any basis, my lord, that's a reasonable, arbitrary.
See, Dr. Mazika, the thing is that now Mr. Yubin has shown that ECR, okay, this ECR record, but it's only by the reporting officer, which is the HOD, correct, which is outstanding, excellent, whatever. Now, the subsequent documents which annexed to the petition do not show the other part of the document. I asked the officer, he said that this document actually contains 78 pages. I mean, reporting, reviewing, and accepting authority, correct? This, what's been annexed here is only of the reporting HOD. And the subsequent certificates had been annexed. They show only integrity certificate, then it goes up to the dean, who's supposed to be the authority, just gives it's just a certificate. There's no grading. So on that point, it was stuck there, we're waiting for you to come back.
If I may present the case from a different perspective, my lord.
Yes.
My lord, he was appointed in March 2019, my lord, subject to condition that he'll bring the character certificate. Within 15 days, he could not furnish a requisite character certificate, my lord, and his appointment was cancelled by an official order, my lord.
Is that on record?
Yes, my lord. Page 64 of the writ petition, my lord. Page 64, annexure 18, my lord. It's dated 27th March 2019. Yes. It says, in pursuant to the adverse remarks in the integrity, character, and conduct certificate issued by so-and-so, read with institute's letter issued by number so-and-so, the appointment order of Dr. Tony Ete to the post of Assistant Professor, Department of Cardiology on ad hoc basis, issued by the institute's letter number so-and-so, stands cancelled with immediate effect.
No, this has no, he impugned this one. Yes. He impugned this one, saying that in view of adverse remarks integrity certificate. Now his ground is that this integrity should not have been taken into consideration at all.
My lord, the question now is, my lord, when a fresh character certificate was issued to him, did he accept that without any dimmer, my lord? After the GC resolution of 14 October 2019, my lord.
Well, I'm not aware of the fact. The only thing is that, see, this certificate, annexure 10.
My lord, may I present the facts, my lord? Few important facts, my lord. My lord, 14 to 19, 2019 was the advertisement, my lord, for a walk-in interview for the post of Assistant Professor Cardiology, my lord. On 9th March 2019, the selection committee recommended him for appointment. The rules say, my lord, Rule 23(1) of the Nigrim's rule, that ad hoc appointment can only be for the maximum period of 2 years, my lord.
2 weeks?
2 years.
2 years.
And 6 months at a time, my lord. Director or no one has the power to extend that beyond 2 years, my lord. Now what happened, my lord? Appointment letter was issued to him with the condition that within 15 days you will bring...
Where's the appointment letter?
My lord.
(47), my lord, page 47 is the appointment letter.
48 is the appointment letter, right?
48, sir.
Forty-eight,
my lord. This is dated 9th March 2019.
Yes.
On recommendation of the selection committee constituted by so-and-so, in the walk-in interview held on so-and-so on 28/2/19, and in exercise of powers conferred under 23A1 of the Schedule 1 of the bylaws of the Institute, appointment, clause 1 says, my lord, the appointment is purely temporary on ad hoc basis for a period not exceeding 6 months. And then on the next page, my lord, it says, clause 12, my lord.
Yes, that's no travel allowance.
After that, my lord, if you accept the appointment on the aforesaid conditions, you are requested to join the post within 15 days from the date of issue of this order. You are also requested to produce the self-attested copies of the following documents as well as its original at the time of joining the post. And 1, 2, 3, then fourth, the important one, my lord, medical council registration certificate and integrity and character certificate from the last.
Last institute means he worked Negrims only.
Negrims only. That is the question, my lord.
Okay, then.
So this was a standard letter issued to everyone, my lord. Now what happened, my lord? He submits a character certificate which was adverse, my lord. That is at page 57, my lord.
Correct, the impugned one.
Yes.
It was impugned.
22nd March 19.
Okay, yes.
This was issued to him, my lord.
Yes.
In this second paragraph, during the period he resorted to his indiscipline, disturbed academic atmosphere and examination process, showed misbehavior and misconduct to higher authorities in Negrims. His integrity was doubtful. So because of this, my lord, his appointment was cancelled, my lord, by a formal order of 29th March, my lord. Now thereafter the matter somehow was taken up by the governing council, my lord. And I'll just place the resolution of the governing council, my lord. That is at page 94, my lord. It starts from page 94. And the relevant part is at page 100, my lord. 100. Page 100. After detailed discussion.
So what happened to the fresh integrity certificate issued?
So the resolution was to allow him to join immediately, my lord. And this resolution was taken on 14/10/2019, my lord. That is after about 7 months from the earlier incident, my lord. So now he is claiming the salary and other things for those 7 months, my lord.
He was not paid anything for 7 months?
No, my lord. Because there was no formal joining by him, my lord.
No formal joining, but even the sense that, see, they should be allowed to join as a doubtful casual is not justified.
Yes.
So should he suffer something that is not justified?
My lord, now what happens, my lord? From this date, the rules provide for 2 years, my lord. From this date, he was allowed to serve for 2 years, my lord. If we count the previous 7 years, my lord, he exceeds the 2 years limit, my lord.
7 years, 7 months means?
7 months, my lord.
It was an aberration.
My lord, he has not performed any official duty during this period, my lord. And there is no formal joining, my lord. And moreover, my lord, in terms of the advertisement, he has already completed.
Now, how did you come to say this unjustified? Was there any other independent inquiry constituted as to Dr. Dean's report? On what basis integrity report given? On what basis? I mean, if it's not what do you call it? His ECRs outstanding. The dean is the reviewing authority. I want to see the other documents. Whether the dean in giving integrity certificate was at odds with under any other certificate given as a reviewing authority.
My lord, our cases, my lord.
I understand. The court understands your case. The court understands your case. Your case is very simple. Years, very simple is that at that point of time, his appointment conditional was like contingent to the submission of integrity certificate, which would be fitting, and then he would have been allowed to be appointed for 2 years. Now, what happened was that he produced one of the adverse. So on the ground of that adverse integrity report, he was terminated. But then after a review by the governing council, he said it is unjustified, he should be appointed. So he was appointed. Correct.
He was appointed for full 2 years, my lord.
Yes, full 2 years.
Fine. For 2 years, he got.
Now what in such cases? Now the 7 months. The thing is that now this dean, whether his action have you made malified?
Yes.
Have you made by person?
Yes.
So his action is malified. Then he should suffer the consequences. Because you can't destroy a person's career by giving, such adverse comments.
My lord, dean is party in the official capacity, my lord, not by name, my lord. It only says dean.
That means it's unjustified. That means this integrity report is not based on any, what do you call it?
Basically, they wanted to destroy my career, my lord. That is the only thing.
Just destroy his career. This happens in these institutions.
Malified intention, my lord.
But my lord, as far as we are concerned, at the most, he accrues a right to serve for 2 years, my lord. That he has already completed, my lord. from 14/10/19, my lord, till
But what should be done to persons like these who destroy other people's careers?
But the career has not been affected, my lord, in my
Of course, been affected.
6 months I am junior.
He has lost 7 months. That means his interstate seniority, whatever it is affected.
But how for ad hoc services counted, my lord? That is.
No, it is counted, my lord.
It's counted.
It is counted.
If we revise from that period.
Yes.
Yes.
Now, my lord, after that, he is not in Nigrims anymore, my lord. He has gone to some other institute. So, and whether ad hoc service will be counted for any purpose, my lord, that also.
Where's he now?
My lord, he is in TRIMS, my lord.
What's TRIMS?
TRIMS is a Toma Riba Institute of Medical Science, my lord, at Itanagar, my lord. He was one of the best cardiologists, my lord. He has done wonders here.
No, that is why does court think his reports is not based on any on any basis, no any understandable, no subjective satisfaction. Because look at his ACR from the HOD who works with him. You've seen his ACR, Mr.
Dr. Misras.
I don't know which doctor. But see, excellent, outstanding, whatever.
But one person is certifying him, my lord, for.
No, that's why I wanted to see the subsequent one. This particular dean who's given this adverse and where the records, what did he write as a reviewing officer? Because as per the officer, as per your officer, it's a composite document of 6-7 pages.
No, and only because he was a student only, my lord, at that point of time. So his ACR is not a full ACR, my lord.
That doesn't exist.
For only permanent staff only we have 5-6 pages. For students only 1 page.
That was his first job, my lord, first appointment.
So that means that proves that there was no materials to issue me. And my lord, integrity, my lord. When you said my integrity is doubtful, that is demeaning. That is amounting to.
My lord, integrity as a student, my lord.
No.
He is resorting to strikes and dharnas.
No, but was any action taken since the point of time? Integrity certificate has to be based on justice satisfaction that this on so and so did, this fellow did this, he kicked the pot or he broke the lamp or he did, all students do that. Was he rusticated at any point of time?
But he was not subject to disciplinary proceedings.
Then why?
Because students.
Not, can you pass a verdict on a person without subject to any kind of proceedings? You think about it, Dr. Mozikari, you have to think in common sense, not plainly like in tunnel vision technical terms. Now a person has been tarnished. He's stigmatized. The governing councils are unjustified.
But to regularize a period when he has not served the institute, my lord, and to pay him for that period, my lord.
My lord, page 144, I can prove that I was serving there, my lord. Of course, I was
without
not
joining,
given
my lord, in a government hospital, how he can serve, my lord?
Head of the department, my
he
lord.
was initially appointed when? Page 48, which date?
9/3/19, my lord.
9/3/19.
Yes, my lord.
Then he was terminated on?
27/3/19.
27/3/19 only. That means after 20 or something, 18 days, 19 days. 27/3/19.
Kindly look at page 144, my lord. What my lord is.
My lord, just one second. My lord, one relevant document is available on record, my lord.
Yes.
My lord, if lordship kindly sees page 58 of the red petition, my lord. A SOCO's notice memo was issued to him, my lord. And that also in 2017 itself.
This is different.
So you file explanation.
My lord, the next page 59 is my show cause, my lord. After that, matter ends. And this was for the welfare of the students, for the institute. And as a president of the Postgraduate Degrees Association, my lord.
Because you see, Dr. Mazika, what the element of what you call it, you talk about element of, you come to basics of elements of like fair trial in the judicial process. Now, if there's any adverse entry in ACR record, a person is, he's in position to expunge the same. Now, in this case, what has happened is that he has been given an integrity certificate which to be adverse, without any like recourse given to him to to somehow like represent against the same also. He represented but has no meaning, and by virtue of that aggressivity, he was terminated from services.
But that has been rectified well subsequently.
Rectified means after 7 months. Rectified means after it says unjustified. Now, unjustified, that means that even the integrity certificate given is not on was not on any basis.
But our difficulty.
So what do you propose to do?
If he counted from March 2019, my lord, then he could have served only till March 21, my lord.
That's all right.
He serves till October 2021, my lord. So 7 months he has to lose either this side or that side, my lord.
You file defamation. You file a damage suit.
My lord, that I will take liberty, my lord, to point.
You see, your prayer also is only to expunge now the remarks.
My lord,
remarks has already been issued. The new certificate has been issued.
My lord, that is.
And also to restore your appointment. Now, restoration of appointment has no meaning because you already left the institute. And number two, expunging also has no meaning. Only thing is that you can have you have a private action against whoever is the dean.
My lord, that I would reserve my rights. But the thing is, my lord, this period, my lord.
But you didn't work. How should you get no work, no pay? Whatever reason.
No, my lord, kindly look at page 144, my lord. This will prove that I was very much there, my lord. And with this kind of adverse remarks, where will I go? Which institute will accept me, my lord? Kindly page 144, my lord.
You bring some authority where
this is from the
because the petition only compensation we can give. Yes.
My lord, kindly look at paragraph number from paragraph number 2 onwards. I will read, my lord. My lord has page 144, my lord. This is addressed to Deputy Director Admin, my lord. Now inviting your attention on various communications sent to the administration regarding the acceptance of joining of Dr. Tony Ite from 12 March 2019 till 13/10/2019. I had accepted his joining in the Department of Cardiology from 12 March 2000, subject to the submissions and acceptance of the character certificate. Further, in the meantime.
Yes, but this now one thing, Dr. Mozi, this is a fact. Is issued by DT. No, this is issued by
HOD. And this HOD, why did he?
My lord, this HOD, there's a CBI against him. There's several inquiry proceedings going on against him.
What does it to do with this letter?
Only to submit that he is in the habit of doing this kind of things.
Oh, that is.
But how far he can get?
Dr. E.C. Fukan versus Dr. Anvish Mishra. They're backing their own horse.
Well, how far this letter is binding on the institute, my lord?
It's not binding. It's just to show that
he was working. Just to prove, because he said that I was not.
But our case, my lord, we could have.
Okay, we'll quantify compensation to you.
We could have regularized the previous 7 months, my lord. Then he has to pay. He has to forego either 7 months, my lord, the previous one or the later one.
What happens that in this 6-7
but then it comes in the realm of a civil dispute. I think you have a case, but not before under 226.
My lord may rectify that period, because my lord, it is
how to rectify a period. The thing comes again now. You serve your probation period. I mean your 2-year. What's the period called?
That's ad hoc period. But that ad hoc period is later on. In between, that's where I was.
No, now you're not permitted to serve beyond 2 years. And how can you say? Then you have to.
It will
come to an end from 9/3/19 to 9/3/21.
My lord, but that period, because that
you served till which by second appointment
16/10/21.
16/10/21.
And that governing body's order comes, my lord, after.
Okay, you explain. You satisfy the court on that point. The court is satisfied. Like it's just like. Operation successful, patient's dead. It's like that.
He has gone and joined. He's already in a good.
No, operation successful in the sense that you've proved yourself that yes, there's no blemish on your career, and then what relief can you get now in a writ court?
Because my lord, I have challenged, my lord. I have also impugned the.
Can we go beyond the rules to say that you'll be entitled to 7 months salary? Get some authorities.
My lord, besides this Dr. Misra's certificate, he can bring some prescription that he
that
he
would
checked
be
doctor patients. My lord, he prescribed. At least
You
he
want
can.
to now start taking evidence here in court
Lord,
on a patient he treated.
My lord, that is absolutely very, to say the least, is absurd, because when, my lord, I was given the responsibility of supervision of the resident doctors for research work, my lord. Research work pending. Now if I am giving a clinical work, my lord, that would create more complications. So during this time, I was given the supervision.
Understandable. Like, how can a doctor who's not in service do clinical work?
Yes. So this proves that I was there very much. I was in the department. I was working. And
they have they discredited this letter of this Dr. Mishra? Have you said anything in the affidavit that this is incorrect? And
no. They have never disputed. And this letter comes on the inquiry by the deputy director. What is Mr. Tony doing in your department? Then he writes this letter as a reply to their letter, my lord.
But you can't be paid for that. You're doing social service only.
My lord, but at the end of the day, my lord, when I was unjustifiedly terminated, it was rectified letter.
I understand you want some vindication, Mr. Yubin.
Yes,
you want some vindication for wrongs be done to you. Then you file a defamation on and whatever and for damages.
My lord, but then my lord, my career of 6 months, 7 months,
forget about that career.
Cannot be quantified by any amount of damages, my lord.
Then you of course, why not? Then it can't be, you can't get relief from the court also. You can't quantify damages, you can't quantify anything. It's just to air your grievances, then you've done it. Because you can't quantify any damages.
Because
always, you're right, it can't quantify damages. But then what do you seek in this petition then?
My lord, because here...
No, what do you seek? What do you want?
My lord, I'm seeking that because that the termination order, my lord, that order was unjustified. The integrity certificate has gone, my lord.
That they've said is unjustified.
If that has, yes, that is why then if they have admitted that we have done something wrong, then it is for them to rectify my career. Now they are saying that yes, what we have done is wrong, but sorry,
you got the authority.
My lord, here, my lord, this is I've given this citation, my lord. This is 2013-10 SEC, my lord.
2010.
Yes, my lord. 2013 10 SEC 324, my lord. It says, my lord, paragraph 38. Paragraph 38, my lord. It says 38.1. The 38. The propositions which can be called out from the aforementioned judgments are: number 1, 38.1. In case, my lord.
One second.
That's
Dipali Gundu.
Yes, my lord. Dipali Gundu, my lord. Page. That will be page 356, my lord. I'm reading the operating part only, my lord. Para 38.1. In case of wrongful termination of service.
Yes.
Reinstatement with continuity of service and back wages is the normal rule, my lord. Here, my lord, we are satisfied one thing that
wrongful termination.
Wrongful, it was a wrongful.
But it's not substantial. It's not substantial service. It's only ad hoc.
It may be, my lord. It may be, my lord, because now this is, my lord. It may be, my lord, but it is a wrongful termination. You appoint me and you terminate me on a basis, and who you appoint me, and the same person who gives me an adverse certificate, and the same person who says that you produce the integrity certificate within a period of 15 days, and yourself is these three persons.
Same person.
Yes, director, the deputy director, and the dean, respondent number 4. These were the chairman. These are the part of the selection committee, and it is their order only, my lord. Who's asking me? He's giving me the appointment order, and you are saying that you give an integrity certificate. And responded the dean, who is also a member, and he gives me integrity certificate. And then the respondent number 3 terminates me from my service. And finally, the ministry, this governing body's meeting, my lord, comes after 3 letters of the ministry. 3 letters, the ministry has called for the entire record. And the three letters comes to the ministry, to the director says that it is not
Very
justified.
influential, doctor, it means.
My lord,
Very influential.
my lord, I'm not influential. I was just asking this thing. They have seen. The ministry has seen. Because my lord, it's a doctor is a life of.
What was his pay?
Pay, my lord.
It went ad hoc.
I think it was 1 lakh something, maybe, my lord. I'm not very sure.
Okay.
1 lakh plus something, my lord.
My lord, in this case, my ambassador is will also come, my lord. The GC resolution says, my lord, appoint immediately. Now, he should not
see the very fact, one thing Dr. Mazir troubles around the court with regard to his claim is that the GC resolution says unjustified.
And appoint immediately.
Unjustified, that means the time to redeem it by appointing immediately. What about the time he lost 7 months? And he's rendering service which has not been rebutted by you all.
My lord, by serving extra 7 months, my lord.
No, that's
not. By serving from March to...
That be treated as what? That can be treated without looking to the second ad hoc. It will be treated as a super, what do you call it, a special period he served with the institute. What's the word for it? There's a word.
Supernumerary?
Not supernumerary post. There's a word for it. It's extraordinary period. It can be treated like that. You take instructions. Because wrongful termination.
But the entire setup is changed, my lord. The then director is not there, then dean is not there, my lord. Then deputy director is not there now, my lord. We just have to defend whatever action we had taken that period.
Because it'll be like, it's like, it's extraordinary. This period taken as extraordinary period beyond the period of ad hoc service which he has served. Because he was wrongly terminated.
But my lord,
if the GC resolution was not there, if it just says that we do not look at the integrity report and we recommend for his appointment, it's unjustified. Unjustified means there has been injustice was meted out to him. That is what, and
to redress, my lord.
In unjustified means injustice was meted out to him, and for injustice which was committed by your institution, since without pointing at any person, he should be compensated in some
form, my lord, but not
some back wages, yes.
But not in terms of regularization of that period.
No. You won't regularize for a period that he served 7 months. That he be paid constant salary of 1 lakh per month. That's it.
Nor in terms of salary, my lord, because he has not served the institute.
Page 70, my lord. May I just show two more page, my lord. Page 70, my lord. This was passed by the ministry, my lord. By the ministry, and this was passed right from 2019, my lord. 2019, May 2019, and
yes,
and 14th May 2019, my lord. It says that it is addressed to the director and said that on perusal of your letter, it has been observed that no new facts, comments have been furnished by the institute in the matter.
Yes.
It is hereby reiterated that the action taken for holding the integrity of Dr. doubtful is not justified. You are again advised to reconsider the action taken by institute and take appropriate corrective measures so that the career aspect of Dr. Otoni Ite may not be jeopardized. This is the second letter. There was a first letter also. Every time they say, please take corrective action because it's not justified.
Just get that word on extraordinary period served.
My lord.
We'll take it again tomorrow.
My lord. Tomorrow I'll be traveling to Delhi, my lord. Thursday I can do online, my lord.
No, it's for them actually.
My lord. And three
we'll
letters.
pass order in court only. It's only thing that just get something because I want to get that extra word. It's not like extraordinary leave is granted somewhere regularized. Suppose a person stays unauthorized absence beyond a period which is allowed under the rules. Then sometimes for some reasons that it is regularized. So this becomes sort of extraordinary leave. In this case also, what has happened is unjustified. Though it is rectified by allowing him to be appointed immediately, but that period remains. And that period, it is recorded unjustified.
My lord.
And that means injustice done to him.
Because he has not served during that period, my lord.
Doesn't matter.
So
he'll be entitled to back wages for that period. We'll hear again on when you appear physically.
Physically, my lord, will be
Tuesday.
Tuesday, my lord.
Yes. This is matter for him on Tuesday. Meanwhile, do my own research also on that. How to that? It's like a period of probation which is extended. Sometimes like that also.
It was not probation, my lord.
It's not probation.
The rules only say that a director can appoint for 2 years, my lord.
Yes, 2 years, right. It's on ad hoc. Correct. Subject to performance, correct?
My lord.
Yes.
6 months at a time and can be for 4 terms, my lord. For total 2 years. Cannot be beyond that, my lord. So we had no difficulty, my lord. Had he stopped on 23rd March 2021, my lord. Then he continues till October, my lord.
Yes, further hearing on
Tuesday, next Tuesday.
Tuesday is
9th.
You get that term.
My lord.